Last week, several members of our community and two police officers, also members of our community, were the victims of gun violence. MPD officer Jamal Mitchell was shot and killed as he tried to render first aid at the scene of a mass shooting. One person was killed and two others are hospitalized with life-threatening injuries. Every day in our community, people live with the trauma of continued gun violence. Once again, we mourn for those lost and injured by horrific acts of gun violence and for their families and loved ones. Once again, we hear politicians talk of heroic first responders and sternly tell us that this must never happen again. But we know it will. We know it will because it has. And we have done very little to address the systemic issues that enable it to continue to happen. Less than 2 weeks ago, the country marked the 4-year anniversary of George Floyd's murder. I was dismayed that no one mentioned Ricky Cobb II, a Black man who was killed by a white trooper from the Minnesota State Patrol during a traffic stop. 4 years ago, we heard politicians promise to invest in genuine systemic change in policing to prevent police violence against community members. Yet what changes have we actually seen? Time after time after time, our Black community is told there can be no criminal accountability because of system barrier after system barrier after system barrier. And they rightfully ask leaders, what are you going to do about those system barriers? Heated debates about minor policy changes ensue until the next Black man is shot by police. And the family and the community is told once again about the system barriers preventing criminal accountability. The same barriers that were there last time. This morning, I am here to talk about some of those system barriers in the context of the shooting of Mr. Cobb by Minnesota State Trooper Ryan Londrigan. My intent is that leaders here in this state find the political courage to remove these systemic barriers. I first want to acknowledge the Cobb family. They continue to grieve a devastating loss amid a political circus that has repeatedly tried to center Mr. Londrigan as the victim. The defense team, paid for by the Minnesota Police and Peace Officers Association, encouraged over 100 supporters to be bussed in, handed out free support Londrigan t-shirts, and created a gauntlet downstairs that the Cobb family was forced to walk through to get to court. Some of them taunted Ricky Cobb's twin brother, Rashad. Members of our staff were frightened at the spectacle, which reminded them of January 6th. How is this behavior acceptable? How is that behavior acceptable? Where is our humanity for the Cobb family? Where is the respect for the trauma that they and the community have suffered? Because make no mistake, Ricky Cobb was the victim in this case. Ricky Cobb should be alive today. And that makes our inability to move forward even more difficult for Mr. Cobb's family and for our community. And for that, I'm deeply sorry. In January, the Hennepin County Attorney's Office charged Mr. Londrigan with the death of Ricky Cobb based on our review of the evidence that existed at the time. This includes the BCA investigation, which was hampered by the refusal of members of the Minnesota State Patrol to participate in interviews. We saw the videos of the incident placed in a format allowing simultaneous comparison of the 3 body cams and the dash cam. and we reviewed supplementary witness statements made in the grand jury investigation. We believed then, and we believe now, based on that evidence, we made the correct decision to charge Mr. Londrigan. In fact, several weeks ago, the defense withdrew their motion challenging probable cause. So as it stood Friday, before we made this decision, we have a clear path to trial. And the easiest political decision for me would be to go forward. But we have chosen not to do that. And I'm going to be talking to you about why. There's been much speculation about why we brought in a firm from out of state to prosecute the case. The truth is that these cases are considered by many prosecutors across the country to be, quote, career killers, because of the potential retaliation against them by law enforcement. In fact, before I got to the office, that happened. That our prosecutors who prosecuted law enforcement, some of them received threats and were retaliated by law enforcement. And so prosecutors across the country, including here, fear they cannot do their jobs because of retaliation by law enforcement. None of this is acceptable. The Minnesota Police and Peace Officers Association, MPPOA, the same organization that opposed a rule which would prohibit law enforcement from belonging to white supremacy groups, paid for 3 private lawyers to represent Mr. Londrigan. And he has a right to a good defense. We were frequently peppered with motions with little or no basis in law or simply factually inaccurate. But we still had to respond to this manufactured busywork. I've mentioned that we are down staff, particularly in our adult prosecution unit. So we were not able to assign the number of prosecutors and staff needed to respond to these tactics. One of our experienced prosecutors said he had never seen anything like this before. The same day we announced charges, the defense posted a video attacking me personally as being out of control and declaring that there was a war on law enforcement which was going to end in this case. I felt personally threatened by that video, but as the case went on, I came to realize that their strategy essentially was to use scorched earth tactics to attempt to intimidate anybody involved in this case or anyone who might consider trying to hold a police officer accountable in the future. And this is a strategy that is being used across the country, which I know from talking to prosecutor colleagues. One expert in this case said that he felt personally threatened by the defense. An example of their motions, one of them, you remember they accused me of prosecutorial misconduct for misusing the grand jury process. They claimed falsely that we asked the grand jury to make a decision to indict, and when they didn't indict, we just charged the case ourselves. That never happened. It never happened. They quietly withdrew that motion once it no longer served their purpose, but that got buried. That got buried after it was the lead. It was after headlines because of the governor's involvement, which I'll talk about later. Some people said, well, why didn't you ask other prosecutors' offices in the state? And the truth is they are very short-staffed. When we have conflict cases, we often have to figure out which other office can handle it because they just don't have the capacity. And this includes Ramsey County. No one else we contacted in Minnesota wanted to be the recipient of the defense attacks that they knew would come along with this case. Now that could have been the end of it, not being able to find anybody in Minnesota who wanted to be the subject of these continued attacks. But we didn't give up. We didn't give up at that time because we believed we had rightfully charged him and that we had a case which we could prove beyond a reasonable doubt. So we brought in the attorneys from the Steptoe law firm. all of whom had been federal prosecutors at one time. We provided them with all of the information that we had at the time. After their review of that information, they agreed that it was appropriate to charge Mr. Londrigan in the death of Ricky Cobb. So they did agree, and let me make that clear, for former federal prosecutors agreed that it was appropriate to charge Mr. Londrigan. But we also told the defense team at that time, and from the beginning of this case, that we would review any new information that they wanted to provide us. And this is an offer that we make in every single case we charge in this office. This is part of my commitment to transparency, accountability, and justice. All investigations are ongoing, even at times during trial. When new evidence becomes available, we evaluate our cases based on that new information. When I became Hennepin County Attorney, I emphasized to our staff that ethical prosecution is constantly assessing our cases and evaluating whether we can or should continue to move forward. In the last weeks, the defense has presented 4 witness declarations containing new information. And for the very first time in court, revealed the substance of Mr. Londrigan's prospective testimony. So what they said in court about what Mr. Londrigan would say if he testified, and I'm just going to talk about 2 parts of it. One was this, that Mr. Londrigan shot Ricky Cobb because Mr. Londrigan feared that Mr. Cobb was reaching for Mr. Londrigan's gun. I want to make it clear here because there was a misstatement in the press. No one's ever said, the troopers have never said, that they were aware of any gun in Ricky Cobb's car or that he was trying to reach for that gun. That gun that was found in the car well after this happened is irrelevant to this. What Londrigan's attorneys said he would testify to was that he thought Mr. Cobb was reaching for his gun, Londrigan's gun. That's something that they had never said before, never told us before. So we went back and we looked at the video over and over in slow motion. And what you can see from the video is that Mr. Cobb's hand at some point does come up. My guess, by the way, is that because Londrigan opened the door, pointed the gun at him and started screaming at him, that his hand was coming up to protect himself. But the video doesn't prove that, and it doesn't disprove what Londrigan says. One of the other things that I think is of note of what Londrigan's lawyers say he would testify to is this. If you slow down the video, you will be able to see, and I think at some point we'll be able to release this, Seide reaches into the car, and he is essentially draped across Mr. Cobb, trying to unbuckle the seatbelt. What Londrigan's lawyers said he would testify to is that in that split second, he realized his partner was draped over Mr. Cobb, and he carefully fired 2 shots into Mr. Cobb's torso so that he wouldn't hit his partner. Now, as to the believability of that, I won't comment. But I will be talking about how that did change our perspective here. The declarations that we got from state trooper trainers, which we hadn't seen before, went to their training and lack thereof, and I'm gonna get to that later on too. It was frustrating to learn of this new evidence so far into the case because the defense had so many opportunities to provide us with it. We even offered Trooper Londrigan immunity to come on in and tell us his story with the agreement that we would not use that statement if we decided to go ahead with trial. The Steptoe lawyers called that agreement, they call it in DC apparently, Queen for a Day. And it simply means, Londrigan, come on in, tell us what you have to say about this so that we can consider it when deciding whether to charge. And if we decide to go forward, we won't use the statement that you made. He refused. He refused to do that, which was his right. But we also didn't know what he was going to say. So we certainly talked extensively about how improbable some of Mr. Londrigan's assertions were, especially coming so late in the process and with access to all of the videos. We also talked about the barriers, the reality of the fact that many of the law enforcement witnesses in this case got lawyers, even people who had no or were not subject to any criminal liability at all. And they were represented by the same pool of lawyers funded by MPPOA. So many would say, why not cross-examine Mr. Londrigan and argue to the jury that he wasn't being truthful? Once an officer says that he used deadly force to prevent imminent great bodily harm or death to himself or others, the burden shifts to us beyond a reasonable doubt, the highest standard in the system, to prove that that was not true. And the expert witnesses in use of force cases focus pretty much only on those seconds when the shots happened and what a reasonable officer could have perceived. So when we got this information, we had to assess what it meant for the case. And we took the new evidence to a use of force expert whose analysis led us to include that based on that new evidence, we would no longer be able to succeed at trial. Why is that? And why wouldn't we just go forward? What happens in trials is this: we present our case. And because the defense had what we call affirmative defense, in other words, they were saying, yes, we did shoot and kill Ricky Cobb, but we had a legal excuse. And that legal excuse was justified use of deadly force. And so we were going to have to prove beyond a reasonable doubt that that wasn't the case. Now, we would put on our case, the defense would put on their case, and then the defense would make a motion for what's called a judgment of acquittal. In other words, judge, we're asking you to dismiss the case because no reasonable jury could believe that the prosecutor has proved its case. We do not believe we would have even made it to the jury. And so that is one of the reasons why I have made the decision not to proceed in this case. I know it's a struggle for people to understand, especially in community and especially the Cobb family. Why not go do that? You know, ethically we can't as prosecutors, but also practically we know we're not going to get a conviction in this case. And what would that mean? That would mean that, you know, once again, community would say the system didn't work, and you know, Mr. Londrigan and MPPOA would be able to talk about, hey, there was a jury verdict. And we then would not really be able to talk as effectively about the systemic barriers that set that up to happen. And so going to trial would also have been a setup here for everyone involved, instead of having the very real, candid conversation about why we need to break down these barriers so that we do not have these issues in every case. I want to acknowledge the team who worked on this case, who experienced threats to their safety during their investigation, and also unnecessary political attacks. No one's job should involve receiving these kinds of threats. So one issue that I haven't seen talked about is the fact that we have a department, Minnesota Department of Public Safety, that is overseen by our governor. Under the umbrella of the Minnesota Department of Public Safety, we have the Minnesota State Patrol and the Bureau of Criminal Investigation or Apprehension. The BCA did the investigation in this report, or in this investigation, in this incident. The State Patrol is overseen by our governor. Our governor, who's been very active in inserting himself into this case. What I haven't seen asked a lot is, hey, Governor, don't you have a conflict here? The State Patrol provides your security detail. You oversee the State Patrol, which has some major issues with training, as I'll discuss a little bit later. The governor, at the request of MPPOA, so let me back up here. So Londrigan's defense is funded by the Minnesota Police and Peace Officers Association. So the defense lawyers and MPPOA have persistently asked the governor to intervene in this case. Have you ever seen this governor intervene in any case involving a defendant in his entire tenure? Ever. Why is it appropriate for a governor who has never picked up the phone to call me, who is not a lawyer, who does not understand the nuances of this case, to talk about it publicly, to center Mr. Londrigan as being the victim in this case? Why has that been appropriate? Why hasn't that been called out? Particularly in the light that you will be getting a report, which is about 60 pages long. You've gotten the summary document of that report, which is about 9 pages. It talks about the problems with training and policy by the governor's own state patrol. So one thing I want to say here, in looking, and I've looked at this video over and over and over, one thing that always struck me was this. Ricky Cobb was detained for over 20 minutes on the side of the road. And that happened in part, he was pulled over because his lights were off. He very quickly turned his lights on. And he kept asking the state troopers, what's going on? Do I have a warrant for my arrest? The troopers said, no, you don't, which was technically true. What he had is a pickup from Ramsey County. And the length of time that he sat there was because the State Patrol had called Ramsey County to say, hey, do you still want this guy? Because if they didn't want him, they were going to let him go. And that hold expired sometime later that day. So in all the time, when you watch this video, Ricky Cobb, a black man who is stopped by white patrol officers on the side of the road, has no idea why he's being detained. None. The troopers never gave him that answer. The troopers never said, Mr. Cobb, we are arresting you. Please get out of the car. They never gave him an opportunity to make that decision on his own. He could have fled, and then he would have been charged with a felony fleeing a police officer. But he was never given that chance. They knew who he was. They knew where he lived. Their policies would have indicated they could not have chased him. They could not have shot after him. Why didn't their policies say, hey, have a conversation before you approach the car about what you're going to do when you decide to arrest somebody? And by the way, tell them you're going to arrest them. Don't keep saying, hand me your keys, and have them questioning why. Why are you asking me after 20 minutes when my headlights were out to hand you the keys? They never gave him that opportunity. There's some who will say, hey, all you have to do is comply and you won't have a problem. And I want to focus us back to Philando Castile, who complied, and yet he was shot and killed. We do not have summary execution or the death penalty for failure to comply. All the troopers needed to do here was to approach the car. They could have put down stop strips under the rear wheels to puncture his tires if he drove away. But all they had to do was say, Mr. Cobb, we are going to arrest you, and allow him to make the decision. Am I going to speed away, get charged later with a crime, or am I going to get out? He never, ever had that opportunity. There were other many decisions which are outlined in the report you'll be getting leading up to and during the interaction that should have gone differently. In fact, the use of force expert that we talked to after that new information said that the tactics here were absolutely horrible. Horrible. And until we as a community demand changes, systemic changes into the policies, the training, the philosophy of our law enforcement officers, this kind of thing is still going to happen. So we made this decision after consulting with Steptoe. Steptoe has written it's about 60-page report. Some of it references grand jury, and to this day, we need a court order from the judge to be able to release that. One of the things we were never able to talk about, which the defense knew. So our hope is to get that order and to release that extensive report to you, documenting everything that happened here. So, I mean, this was one of the hardest decisions I've ever made. It was, on the one hand, not so hard legally, but people in our community and Ricky Cobb's family shouldn't have to listen to me or any prosecutor, once again, talk about the same legal barriers that prevent accountability time after time after time. My commitment to them is that we will continue to advocate for these changes, because that is the only way our community is going to heal. Thank you, and I'll take questions.
Mary, did anybody on your staff advise against charging Lonergan in the first place?
So I would say it was an ongoing process, and it was more about how, was there any way of getting additional information? There was some concern that, when we talked to Noble, by the way, what Noble said was, I can't really give you an opinion because I don't know what Lonergan's going to say. If Lonergan says he shot to keep him from driving away, that was an unlawful use of force. If Lonergan shot to prevent imminent bodily harm or death to his partner, that could be a lawful use of force. So as with any case, we have extensive discussions about, how are we feeling about this case? How are we feeling about the training? And after the grand jury and getting some information about their training, which we thought we knew until we got these other declarations, we felt comfortable moving forward.
Okay, so as a follow-up to that, would you still have charged Lonergan if he had made a statement saying that he thought Ricky Cobb was reaching for his gun, reaching for Lonergan's gun?
Yeah, so if he had made that statement, and it wasn't only reaching for the gun, that's not the only thing here. It was also about why he shot. Because, as I said, one thing Noble told us was it depends. I mean, we can't assume why somebody took the action that they did. And so the other piece of it that we never knew until we appeared in court and heard this from the defense was he says he shot because he feared that his partner was in imminent danger of great bodily harm or death because he had reached into the car. Now, part of the training issue that's problematic is there didn't appear to be training saying it's not a good idea. You should not insert yourself into a moving car. But one of the issues that came up was, well, Lonergan can't be penalized for Seide's bad decision-making there. So I don't know, but it certainly would have, I guess if we had received the same information we have now, then it may very well be that we would not have charged it.
Just to step back on that, though, this is not the first time that a police officer in a case like this or a law enforcement officer has made a statement saying, I feared for my life, feared great bodily harm. I mean, it comes up in every case.
Yes.
And it's the way that you're constructing this, it's like it's new evidence, like it's a surprise that the law enforcement officer would make a statement like this. I mean, if they had this trump card in their pocket all along, why even charge the case?
Well, how do we presuppose what somebody, theoretically, a person should be telling us honestly why they did something, right? We can't just presume, they're going to say this. And there was a significant component of training here. And this is part of the systemic change that needs to happen. There were many, many bungled opportunities here. There was also, and some of this I can't get into very much because of the grand jury, but they had some training on extraction from a car. They didn't follow that training at all. And so it's difficult for us. We're looking at the totality of circumstances. We're looking at the fact that none of this would have happened except for the environment that the troopers created. And one of the issues, as you said, is none of these protections apply to ordinary community members, right? Community members who are claiming self-defense or something like that cannot be the first aggressor. They have to retreat. There are all kinds of things that protect police officers. And so it's a different analysis. But when we looked at this, considering all of what we thought the training was, and also going back and realizing that the State Patrol trainers were not cooperative, not all of them. And they did not, that we had to convene a grand jury to actually get them to hear what their statements were. And one of the things Noble wanted was more about their training. He wanted to know, were they trained about extraction? So you can use some training in the determination of what happened here. But ultimately with the declarations, we learned that when those people that made the declarations were gonna say they followed their training, it was very hard then, you can't hold an officer criminally liable because they have bad training. Because they weren't trained, don't put yourself in a moving car. Because they weren't trained, hey, you can put the stop sticks under the rear wheels. Because one of the things we heard at some point here was we couldn't put stop sticks in front of the car because that would have endangered our lives. And the expert that we consulted after the fact said, just put them under the back wheels. So the fact that there were many, many, many other alternatives here don't matter under the law.
What did the county attorney's office think the training looked like before the investigation, and how does it compare to other law enforcement agencies?
And that's where much of that came up in the grand jury transcript, which I can't talk about at the moment, but that will be laid out, that is laid out in depth once we can get that released. I think one of the recommendations too is that the training and policies about what officers do or troopers do before the use of deadly force cannot be completely separated from every other policy. In fact, you cannot create the conditions that allow you to then claim, oh, I was afraid. But they are completely separate, and that's problematic.
Given all these systemic issues that you're taking with the training of the State Patrol, I mean, I assume that your office gets some cases that involve State Patrol.
Yes.
Is your analysis gonna change or you know, in terms of how you, how much trust you put in the law enforcement statements and their, you know, their ability to do their jobs?
Yeah, I mean, with State Patrol, we have had some conversations with them. They seem open. And certainly we're gonna be having conversations about, hey, look at these recommendations and can we offer our help in really revising some of these critical policies and the training that comes from that. There's a new colonel there. We've had some conversations with her. So my hope is that they will, in good faith, engage and look internally and really think about this. And I think this is a fundamental problem with all of law enforcement, that they are trained to control. They are trained for compliance, right? And so one of the interesting things in one of the troopers' statements, they were asked if there were any other alternatives here, and he never said, I could have let him go. I could have let him go, because I don't think officers are trained to think that way. There seemed to be, you know, two alternatives. He was gonna get out of the car, or I was gonna rip him out of the car. Not, we knew exactly who he was. We weren't gonna chase him, we would just go pick him up. That seems to have never occurred to the troopers in this case. I think understandably, because that is not how police are trained to think about these situations. And I think they need to be. They need to understand that both they and the person they're interacting with should both go home at night. Because the officers frankly put themselves in jeopardy here. There was no reason to put themselves into the car, but they did that. They did that, and we don't want that either. We don't want officers putting themselves in danger of injury. But they have to be told, there have to be policies, there have to be training that it is okay, acceptable, and expected that in some situations, let the person go.
Can you give us an idea of the cost and the amount of time spent by Steptoe, what the dollar figure would be from their help? And also with
Yep.
that, was creating these recommendations, was that part of the deal? Like, was that in the
No.
contract, something they were supposed to do?
No. No, in fact, I had every when we, and I don't know what the number is now, we'll get that to you. But here's how the process went. We retained Steptoe, sent them a bunch of documents, because the first thing was, did they think our charges were appropriate? That was the first thing, because if they said no, that contract was done, right? So they looked at the materials that we sent them. They decided that our charging was appropriate. And then they put in, as you know, or not a certificate of representation, but they became the lawyers of record. And so no, at no point did I ever expect, I mean, we didn't hire them to do, here, you know, we're gonna dismiss, here's an independent, I want you to do an independent investigation of what happened here. That is not how this went. They appeared on the record, we all expected to go forward at trial. But then when we got this information, we had an ethical obligation to look at it. It was after we got that information that we then consulted this other expert. So our own expert, given that information, was saying, we just can't go forward. So we had that conversation. As you know, and I've said this in the past, I retained full responsibility and accountability for deciding whether to go forward. Steptoe made a recommendation to me. I accepted that recommendation. And then we talked about, hey, there were so many problems here, really systemic problems as well, that they then worked on this report. The report is meant to outline everything that happened here, but also to give us steps forward. Because I can't stand up here again and say, this is the way it is. This is the way it's always going to be. There are these system barriers, without saying we are going to fight to try to make sure that some of these system barriers are changed so that agencies like state troopers, if this comes up again, they handle it very differently. And the next Ricky Cobb isn't the next Ricky Cobb.
One more question.
Mary, why the timing right
about-
now?
Eric?
Oh, sorry.
Yeah.
Sure. County Attorney, you made mention about these alleged threats that came into your team
Yes.
during this case. Did that lead to some in your office not wanting to handle this case? Is that why you looked outside? Because of those threats, you reached out to Steptoe?
That was a part of it. It's also a part of it that, who wants to be, you know, people who work in this office, many of them are career prosecutors. They're here for the work. Nobody wants to be put there out on social media with their pictures subject to all of the attacks that we get, that I get. And then having the governor weigh in and question our staff's integrity, nobody wants to be the subject of that. So it was a combination of all of that. And a combination of, as I said, people fear retaliation from police. And by that I mean slow walking cases. I don't mean, you know, physical harm. What I mean is they don't work up the cases. That has happened in this office. I didn't know that until I got here, and I was told that. It's a passive aggressive, we're not going to help you because you worked on this case. And that's unacceptable. But that is a fear that many in the office have. And it's not a fear isolated to our office. I have talked to my county DA counterparts across the country, and they experience it as well, which is one of the reasons why some of them have created a separate team to handle these cases with lawyers that don't have to work with law enforcement every day.
But what about the
One
last
question.
Yeah, Mary, just on the timing here, I mean,
Yeah.
I do understand certainly the optics of what this community is grieving right now with law enforcement.
Yes.
Was that part of your calculus? We're curious about sort of the Sunday night release, why now,
Yeah.
why right now? And then where do you go to rebuild community trust on both sides here?
Yep.
The next time tragically one of these cases are gonna be presented, neither side
Yep.
buys into you right now.
Yeah, the timing of it, the report, like I said, it's about 60 pages long. It had nothing to do with the tragic murder of Jamal Mitchell and other community members. And so I'm going to say that I said, you know, we as leaders and our political leaders I don't understand why we consistently say we have brave first responders who have to run into these situations when we as policymakers could do something about that. We could do something about the gun violence that impacts first responders. And the other piece of this, given the timing, is that we can hold two things. That yes, there have been increased assaults on law enforcement. And we had the tragic situation in Burnsville and now what happened last week. But we can't get sucked into this narrative of there is a war on law enforcement. We have to be able to also say, hey, we need to have accountability with police as well. So no, it has nothing to do with that timing. Also, I was elected by the people in Hennepin County to make ethical, courageous decisions. I would say, and we already have said to law enforcement, the easiest thing I could have done was to go ahead and try this case. That would have made them happy. I'm not saying that. But if for those who say this was a political decision, absolutely not. I think I've made it very clear in my tenure as county attorney, I don't make political decisions. I make the ethical decision at the time. And so what I would say to everybody is, I think, this is the kind of county attorney everybody wanted. Not one that made decisions based on politics, but one that made decisions about the information we had at the time, who is willing to look and see additional information. As I said, I've told our staff, there's no shame. It's not a bad thing. You charge a case and new information comes in, we have to be looking at that. And it's not a failure on your part to say, it just doesn't make sense to go forward anymore, because people in this office used to do that. They used to do that. And I've made it clear to all of them, we must not do that. That is our obligation, our ethical obligation as prosecutors.
Talk more about that.
Thank you.